The Republican Supreme Court majority rewrote the federal criminal statute relating to the obstruction of an official proceeding to exclude the mob attack on January 6 that was intended to disrupt the joint session of Congress being held to formalize the certified state election results. The purpose of that attack was to disrupt an official proceeding. Two of the four federal criminal counts against Trump involved that criminal statute. The criminal statute that the Supreme Court justices decided to rewrite clearly and plainly applies to the Republican assault on the nation's capital on January 6. I have copied this short statute in the More section below and will read it now. Whoever corruptly 1. Alters, destroys, mutilates, or conceals a record, document, or other object or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding. Or 2. Otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. The Republican justices in the majority claim to be using a plain meaning textualist approach when interpreting a federal statute, and that's true when the approach yields their preferred policy result. When that judicial interpretation standards cannot be made to work for them, then the Republican justices will do something different that achieves the desired policy result for them. That is true, in my opinion, for all of their claimed judicial interpretation standards on important issues. If the standard achieves the correct ideological or religious policy result that they desire, it will be used. Otherwise, it will not be used. I previously discussed the Fisher case in a video that I published here on YouTube before the Supreme Court rendered its decision this week. And I will link that discussion in the More section below. I expected the end result of the decision would be to protect Trump from criminal charges under the statute, and that has now been done. The Supreme Court, in effect, deleted the word or and the entire passage that comes after the word or. And that achieved the desired result to protect Trump from the criminal charge of obstruction of an official proceeding. That charge can now only be made if the Section 1 part of the statute, which involves a document, comes into play. So they have to destroy or mutilate or conceal a document for an obstruction charge of an official proceeding to be made. What happened on January 6th is no longer an obstruction of an official proceeding, and that had to be. And if that's the result that you want, you just delete the second part of that statute. I'm discussing Supreme Court decisions here not to convince people about policy matters. I mean, most of these important social and policy matters are strongly held by individuals, whether it's abortion or gay marriage or some other issue. I'm just highlighting the ongoing effort by the Republican justices to return America to the late 19th century, and that is called conservative by them and their supporters in the Republican Party. For most of its history, the Supreme Court has been a deeply reactionary institution, and that is not appreciated by voters. I will do a video at some point to go into more details about that subject. There is no stopping this most recent strong reactionary turn in the Supreme Court, given the 6 Republican justices who now control the court. A remedy is not to pack the court, because once you go along that path, you'll end up having to hold a Supreme Court oral argument in a college basketball stadium just to seat the judges. The only remedy in our democracy, which is skating on thin ice now, for those opposed to the direction, is to play the long game like the Republicans did, that resulted in the reversal of the 1973 Roe v. Wade decision and their decision yesterday to reverse the Chevron case decision. And that requires a steadfast, multi-decade vote against all Republican candidates for office, never making an exception, starting with the lowly state House representative through the House, Senate, and presidential elections. If Trump wins in November, which appears more likely than not to me now, Alito and possibly Thomas will retire and allow Trump to appoint younger versions of those 2 justices, like he did with Kavanaugh and Gorsuch. And that would cement the current direction of the Supreme Court to 2050 and beyond. Elections do matter. Republicans realized that as it affects the Supreme Court decades ago, and I don't think it's occurred to the Democrats yet.